I'm really honored to be able to introduce Anton. She's a professor at North Carolina State University. She's really known very heavily in the privacy circles, and as a computer scientist, that's not very easy to do because you have to walk both the policy side and the computer science side. But then she comes up with these great solutions, and she's really been able to show great integration. And I've had the opportunity to serve with her on numerous panels, and she does advisory boards from everywhere from NSA through corporations like Intel and everything in between. So a lot of people really listen to her as well. She focuses a lot on software engineering and the requirements and so forth, and I'll let her talk more about exactly what she's going to say.
Thank you. Can everybody hear me? Yeah. Okay, good. So it's a real honor to be here, and I've been looking forward to coming. I was very excited when LaTanya invited me, and as you all know, she's extremely well known in the privacy community as well, and it is fun to serve with her on these boards as we come at this problem from different perspectives. So I'm going to talk a little bit about the work that we've been doing at NC State in looking at how we can design software systems so that they comply with law. And the work that we've done has really evolved over the course of 10 years, and so I'm going to kind of guide you through that process and how we came today. So privacy is a grand challenge. It was noted as such in the CRA Grand Challenges Report for Information Security a few years ago, and basically this is just a general outline. We'll talk a little bit about privacy policies, the legal landscape, work that's been done with legal text, how we can develop, what requirements do we have for handling legal requirements, and what we're doing in terms of trying to obtain to reach a point where we have regulatory compliance in systems. And then I'll make some general recommendations that span all of these. So we've been studying privacy policy and healthcare privacy for about 10 years. And more specifically, we've looked at regulatory compliance for about 5. And obviously, we know that a lot of what we do today entails collecting a lot of information and surveillance, and so people care a lot about that. And for people to feel comfortable and willing to use information technology, we need to be able to let them know that we're safeguarding their information and that we're protecting their privacy, and let them understand how they can control their own information and their privacy. So I mentioned privacy is a grand challenge. Why is it a grand challenge? Well, we want to try to avoid how expensive it is to deal with things when it's too late. So when you have a data breach, it's too late. We should have done something earlier. We know that when you're doing software requirements, that the sooner you identify a problem with the requirements, the cheaper it is to develop your software and the more expensive it is to fix an incorrect requirement. And so we want to make sure that we're looking at policies as well as law to make sure that we are incorporating that early on. So it used to be that, this is one of those age ones, right? How many of you remember this? Yeah, that's what I was afraid of. So it used to be that on the internet, no one knew you were a dog, okay? And we used to make jokes about how, those of us who had web pages already in like 1992, the women, we would get these marriage proposals from all over the world because we're like the only women on the web. And so we all thought about putting a picture of a dog up. So they get to your page, oh, she's a dog, let's go on to someone else. So it used to be that you really were anonymous. Nowadays, though, not only do they know you're a dog, they know that you are a 4-year-old German Shepherd Schnauzer mix, that you like to shop for rawhide shoes, that you visited Lassie's website 213 times, that in a chat room conversation you said that the third Lassie was the hottest, that you've downloaded photos of the third Lassie and emailed them to a few dogs, and they know the identity of those dogs too. So privacy, so the internet is not what it used to be. You are no longer anonymous. And privacy means different things to different people. So here's an example of privacy for LaTanya and I, right? Trying to maintain somewhat of an anonymous look. So online, how do you assure the public? How many of you have ever read a privacy policy? Yay! That's actually a lot of people. That's good. So I bet this is how you felt, though, when you read it. It says, congratulations, Dave. I don't think I've read a more beautifully evasive and subtly misleading public statement in all my years of government. Okay. So unfortunately, this is really the case. And so one of the things that we've been working on in our group is trying to figure out how can we make privacy policies more understandable. So I won't belabor this, but privacy policy basically states an institution's practices in terms of how they use, collect, and maintain information. And the FTC likes for companies to put these on their websites. And so what we've been interested in is how do you assure that the policies that you have comply with law? How do you make sure that your software requirements and system requirements comply with the policy and law? And what are your policies in terms of how you're going to handle information across different system boundaries? Okay. And so what makes this difficult, one of the things that makes it difficult is that there's so many different understandings and social and legal implications and definitions for privacy. So we've, as a basis for our work, we look at teleological models, which are comprised of strategic and tactical goals. This is based on my dissertation work on goal-based requirements analysis. And so what we found in our work is that focusing on goals rather than requirements, which goals tend to be less volatile than software requirements, we can communicate with stakeholders in terms of their values and what they care about, and we can actually derive these from policies very systematically. And so how would we do this? So this is a privacy statement. I think this was from Eckerd Drugs. And basically we're sifting out actors, action words, subjects, and any constraints or conditions on the statement. And so we've analyzed over 100 privacy policy documents. Actually, some students who've done this are in the room. Some of my former students are here. And so what's challenging is that we have all these different keywords. So we have a tool that we developed to help the requirements analyst run through this process. But we have 57 different keywords, and they're not used in the same way across websites. So then you have to develop heuristics for if inform is used in this context, then it is an inform goal. But if notify is used in the same context, it really should have been an inform and not a notify. And so it becomes really challenging to try to get to a point where an end user could compare privacy policies kind of fairly to determine who they want to entrust their information to. So when we do this goal identification process and find these privacy policies, we then classify them. We have a taxonomy. This is work I did with Julie Earp in the College of Management at NC State. And so what we found when we did a content analysis of all these privacy policy documents is that everything generally maps to privacy protections, which generally map to the FIPS, and privacy vulnerabilities. And so these are ways in which your information might be vulnerable to a breach or to some disclosure that you were not happy about. And so these are threats to your consumer privacy. And then once we do that, we eliminate redundant goals, and we identify synonymous goals, et cetera, and we have a goal to support it. So when we did this content analysis, we were very interested in seeing, well, are consumers worried about the same things that are expressed in privacy policies, and what are consumers concerned about? So we developed a survey instrument. We ran the survey back in 2002. We had over 1,000 internet usable responses. And what we found was that consumers are most concerned with, in this order, information transfer, notice and awareness, and information storage. And yet, what was emphasized in the content analysis that we did in the privacy policies was data integrity and security, information collection, and user choice and consent. So clearly, there was a misalignment and a complete mismatch between what end users want to see in a privacy policy and are concerned about, and what companies are expressing in their privacy policies. And so we've presented this to CPOs, and they've really taken it to heart, those that have heard it. And so we've had CPOs come up to us afterwards and say, I'm going to go back to my company, we're going to revisit our privacy policies. We want to make sure that we're addressing the things that end users are concerned about. And that's great. Mm-hmm.
Can you talk a little bit about what sort of methods you use to elicit consumer demand, and how you sort of, whether you did sort of an engaged and informed process or a survey, or how do you?
So so Julie Earp is our sociologist on the group, and so there's a whole process on how you do this, which I was completely oblivious to until I started working with her. So it takes like a whole year to develop this instrument. So we first we did the content analysis, and so we knew what we were kind of trying to gauge against, and we were trying to get a baseline for what people cared about. And so we did a little pilot study. We created the survey, vetted it with a bunch of experts. And then we did a pilot survey. Then we had a focus group. And then we revised everything. And then when we do factor analysis, we make sure that the questions are in fact asking what we want them to ask, and that people are interpreting them in the right way. And then we do the full survey. So it takes about a year. It's a lot of work. So with the survey instrument, which we published in 2005. We reran the survey this year. So y'all are the first people seeing this. This hasn't been published yet, so hot off the press. So since our first survey, here's what we found. Respondents are more concerned about personalization and transfer than they were back in 2002. So they are concerned about personalization for customizing their browsing experience, for marketing and research, and to monitor their purchasing patterns, and especially for disclosing to third parties. This is really timely right now because there's so much attention being paid to behavioral targeting, behavioral marketing right now, and the FTC is very interested in this. And we have Representative Boucher who wants some kind of laws in place to govern this. So we're trying to quickly write this up because we think it's going to be of great interest to that community in DC. Respondents are less concerned about notice and awareness. So they're not so concerned about deciding how their information will be used, about websites disclosing how their information will be used, or changes in privacy policies. So why might that be? Well, how many privacy policies do we get in the mail now? It's like every time you get your credit card statement, you have another privacy policy. And so I think people, this is just conjecture on my part, but we've kind of become desynthesized. You get so many of them now, it's just like, oh, I don't have time to read this, and I can't understand them anyway. So that's interesting and it has changed. But people do want to know about the security safeguards that are being used to protect their information. All of this is statistically significant, by the way. And so I also looked at what were the top concerns, and you can see that information transfer is still a concern, but it's dropped a little, and now we have personalization and information collection as two new concerns. So this is work that we are still analyzing data. We have sufficient information from Europeans. We had over 2,000 respondents this time, and so we have enough international respondents that we're also going to do a comparison between US versus international values as well. So stay tuned for that. So, and this is what you don't want, right? Ask about our privacy policy, can't say it's private. So now another thing that we did was we looked at user perceptions versus comprehension of policy. So this is work that Matt Vail, one of my master's thesis students, who's here, Matt, did this work for his master's thesis. So he can correct me if I say anything wrong. So we designed an experiment to gauge perception of different alternatives to natural language policies, and then we were trying to measure comprehension of those policies. And we used the taxonomy I mentioned as our theoretical framework for this. So we had three blocking factors. We used drugstore.com, healthcentral.com, and Novartis. So drugstore.com had more vulnerabilities in their privacy policies than protections. HealthCentral.com had an equal number of protections and vulnerabilities, and Novartis had more protection goals than vulnerabilities. So we had, in addition to that, we had 4 different variants where we used the original natural language policy from the website, each of which we changed the name of the company. So we didn't use the name of the company, we just said brand X for all of them. So we had the natural language policy. We had a list of just the privacy goals and the vulnerabilities. The third one was the categories based on the taxonomy. And so if you clicked on one of the categories, it would pop up the list of practices associated with that particular category. And then finally, we had the original natural language policy, but as you hovered your mouse over the policy, it would pop up a goal statement that corresponds to that statement. So this is what they look like. You know, dear friends, first and foremost, brand X is deeply committed to preserving your privacy. Right, so right off the bat, warm fuzzies, right? All right, so this is an example of a list of goals and vulnerabilities. So maintain confidentiality, PHI, PII, guard personal health information, et cetera. And then this is the categorical list where you could click on any of those red links, and then it would pop up any relevant definitions and the policies having to do with that specific category. And then finally, the natural language where you'd get these little pop-ups as you hovered your mouse over it. So that's what it looked like. And then just to show that we were actually doing real science, we had a block design, you know, and we had, of the usable responses, we had a pretty good distribution across all the different possibilities. So, comprehension summary. Users were comprehended the natural language policies the least. And then adding the goals increased the comprehension a bit. And then there was a significant increase in comprehension when we provided the categorized goals. Okay? And then across the board, though, the scores were alarmingly low. This is kind of interesting. It kind of surprises, but by the same token, if you think about it, it really doesn't. People generally do well with abstractions. And so if you're abstracting the categories, and then you're just showing, they drill down, then they're going to remember those categories pretty well. And so that was very useful, and it's a good alternative to the way that policies are currently being expressed. Yes?
For your, when you say the scores were alarmingly low, is that kind of across the board, or did that cluster or change at all depending on age group or anything like that?
So this is really interesting. There were absolutely no demographic influences on this study with the exception of one. And that was that people over 67 years of age performed worse on the comprehension than every other group. But there was no cultural differences, no gender differences at all. And given that my father was one of the ones who took that, I kind of wasn't that surprised. So, anyway, so that's an interesting question. Yes?
How did you measure comprehension?
Put Matt on the spot.
Oh, it was a couple years ago, I don't remember.
Oh, yeah, okay, so I'll tell you.
I think we basically posed questions, like in a quiz form. So we gave them, I think, a list of 3 or 5 questions about the policy, and there was a multiple choice, and there was a correct answer.
Right. And we tried to make them not very obscure. They were pretty simple questions, like if they read it. Oh, one of the things I didn't mention, by the way, in terms of trying to do this, is that we asked whether people had read the policy or not. And if they didn't, we didn't include them in some of these studies in some of these results that we're showing. And also, if someone said they read it, but they only spent like 45 seconds on the consent form as well as reading the policy, we knew that there's no way that anyone could read all of that in that short a time. And we threw out all those responses. And I'm throwing out 45 as a guess. I don't remember what the exact number was, but we did a test to see what was an average time for someone to be able to read it all, and we threw that out.
Is 67 also random instead of 65?
I'm sorry, I'm not understanding.
You said over 67, the results were different. 67 is random?
Actually, I don't remember if it was 67 or 65. We've done surveys in the past, and we're using the same demographic breakout as we do on all of our surveys. So I'm guessing it's 67. But I think I have a slide where I have it.
I'm curious if you also considered putting up policies in a standardized format, like P3P, and presenting that, or was P3P not expressive enough?
I would say that P3P is not expressive enough, and that's not what we were trying to do. This is what is actually read on the policy. Like, this is what a company would post on their site rather than some kind of machine readable.
Well, the idea would be that instead of obviously you wouldn't give a person a machine coding of it, but the idea would be the user would have, instead of say having to read text, would have sort of a graph where you would tick off boxes. Or is it simply you can't?
There have been a lot of studies about P3P, and we were really trying to do something different, in all honesty. And we have done studies with P3P as well, and compared it to other things. I think we have one paper on that. So, in summary, okay, so I don't have the slide on what the age group was, but it's in the paper. I'll be glad to provide that for you. So, summary is that users believe that they were more secure sharing their PII with websites that display the natural language policies, especially the ones that highlight the goals and the vulnerabilities. They felt that those that had the highlights would protect their information the most. So it was kind of almost like it was perceived as an extra transparency, okay, which is nice. And the 2 natural language variants were perceived to be expressed more thoroughly than the alternative expressions. However, even though they felt most protected with those were the 2 that they comprehended the least. Okay, so there's a movement, the Federal Trade Commission is very interested in trying to come up with short notices, and this is a some clear evidence that that's actually a really good way to go if we really want to help people understand how their information is collected and used. So now let me switch to talk a little bit about the legal landscape. So we've talked a lot about the end user, the consumer, perceptions, et cetera. So let's talk about legal landscape now. So According to Ernst & Young's global survey, actually I forgot to update the slide. They've done this now through 2008 as well. Compliance with regulations has been the primary driver for chief information officers at global companies around the world. And we know that we now have privacy laws that require companies to enforce their policies, that consumers are more concerned about violations of their privacy, and that companies are increasingly being held accountable for this. So we need machine-readable and machine-enforceable policies, and we need to be able to do this to consistently apply our practices and make sure that we are less prone to breaches. So this is a typical diagram of what happens. You specify your system requirements, you design it, you deploy it. Whoops, you get a legal complaint. So what do? Well, I guess we better go review those regulations, and maybe we need to identify some requirements that we didn't have. And oh, now we have to specify new requirements, we have to refactor, we have to do all this stuff, and it's expensive, and it's a mess. And so industry best practice would be to always review the regulations when you start out. Now, this is a challenge because we have a lot of legacy systems, and then new regulations come into play, and you're not designing a fresh system. So that's a challenge. But you review the regulations, you identify the requirements, you specify the requirements, you design and deploy, and then the only thing you have to do is worry about changes or case law that might come about. And we have a paper already in 2006 on that first part, and another one in 2008 on the second part, and I'm going to talk about that. So also consider we have data mining for anti-terrorism. We have lots of data breaches like the choice point data breach, which I'll talk about in a minute. And all of these have been perceived with public outcry about it and perceived as violations of our privacy. In addition, consider this. I've highlighted what I wanted to stress here. So here it says over 40% of federal health insurance contractors and state Medicaid agencies reported experiencing a privacy breach involving personal health information in the past 2 years. Okay? Not good. We don't want that. In addition, Blue Cross Blue Shield last year sent physicians copies of health insurance applications with a letter advising them they had the right to drop members who failed to disclose material medical history in their applications. And so luckily, the California Medical Association for Physicians was outraged and didn't do it. But if you wonder, well, people shouldn't be so concerned about health insurance companies. Well, yeah, actually they should. Because they're trying to find any way to deny them the ability to have insurance. And then here, we also have that HHS has not come up with a way to tie together the various initiatives it has ongoing to tackle the thorny privacy and security issues related to exchanging health records electronically. So clearly, this is an important space to be working in. And this is what you don't want to happen. Your DNA doesn't match your credit history, sorry, can't treat you. So why should computer scientists study the law? Well, I mentioned already regulatory compliance is a primary driver for industry. Look at the cost of non-compliance. So HIPAA can be up to $25K per individual violation. And then the Fair Credit Reporting Act, we had that was become a landmark case for choice point. So there was a historical civil fine of $10 million that they had to pay to the Federal Trade Commission. They had to set up a $5 million consumer redress fund. In addition to that, and they also had to start doing security audits every 2 years for 20 years. Moreover, if you look at all of the information, including all of the money that ChoicePoint ended up spending, including this $15 million, they spent $28 million re-instrumenting their business practices and their software systems to ensure they would not have this kind of data breach in the future. And they dropped clients in terms of part of their business practices. Clients that didn't want to adhere to their new business practices, they dropped. So a lot of other data brokers got those clients, right? And these other data brokers have not changed their business practices. So we're just waiting for a data breach for them to actually do something about it, which is unfortunate. But ChoicePoint has actually become a good citizen. And they're frequently at a lot of the privacy meetings talking about the changes that they made to make sure that these kinds of things don't happen in the future. But think about $28 million. That's a lot of money. It would drown many a company. ChoicePoint was able to absorb it. And you might say, well, were they really? Because they got bought out by LexisNexis shortly after that. Right? So, but you want to avoid that. So law is dictating a lot of aspects of software and system requirements. And we need to be able to be accountable for that. So looking at the space of HIPAA compliance, my student Travis and I did a search one day on HIPAA compliant software, just out of curiosity. So the first one said, our software fully complies with all current HIPAA regulations. And the very next one says there is no such thing as HIPAA compliant software. So, you know, we're clearly sending mixed signals, and we really have no idea what we're doing in this space. So how does the law impact requirements engineering, which is my area? I'm not a security person. I do work in privacy, but by training and in terms of my research, I am a requirements engineering researcher. So in requirements engineering, we do elicitation. So you're determining the stakeholders and the requirements. And that has a lot in common with what you need to do when you're analyzing legal text. And so we have requirements that are specified in legal text. We have stakeholders, and we have to figure out who those stakeholders are. And with respect to HIPAA, you're dealing with physicians and you're dealing with lawyers who can help you interpret the law. We do analysis in requirements engineering, where we're removing ambiguities and contradictions and omissions. And there's a lot of ambiguity in the law. And we'll talk about that. And then we're also very in tune with doing traceability. So we need to be able to maintain traceability so that when there's a change in the software or a new requirement, we can go back and see what the impact and the scope of that change is. And so that helps us to be more efficient in how we develop software. And this becomes extremely important when you're talking about legal requirements. So what is required for legal compliance? Well, analysis, modeling, and development activities in software engineering are very applicable here, as are traditional security activities like policy enforcement and auditing. And so we've written a paper. This is work that I did with Paul Otto, one of my PhD students, who's also doing a JD. So he's a JD PhD student. So we looked at what are the factors that make legal text so difficult for software engineers to deal with them. And so they're very hierarchical in nature. They are frequently amended and with revisions. Okay, so keeping track, you know, we don't like a lot of change in software. It's expensive, it's a headache. Well, the law changes, and that's a pretty significant high priority thing that we have to be able to address. There are a lot of cross-references, internal and external. And one of the things that's really interesting, one of the things we've tried to do in our work, is a lot of the work that's been done in this space, there are all these internal cross-references within a law and or within a regulation, but then there are a lot of cross-references to other laws. Okay? And there are exceptions that law takes effect rather than the one you're using, or vice versa. So the work that's been done often will say, well, we assume that this is the priority and that there are no other cross-references. Well, what happens when you do that? That's when data breaches happen. That's when you fail to comply with the law. And so we've been working on how do we develop techniques to ensure that we can do that kind of cross-referencing and that is reflected in the software. There are a lot of definitions and acronyms. There's case law and supplemental documents, and there's unintentional and intentional ambiguity. What's interesting here is that the unintentional ambiguity is the kind of thing that happens in software engineering. It's like, oh, well, maybe we should have been a little more precise. Okay. So when we say quickly, well, how quickly? Right? When we say retention period, well, what's the length of that retention period? But there's a lot of ambiguity in the law that's intentional because they want it to be interpreted by the courts. So as software engineers, we don't like that, but we have to live with it. And so how do we address it? So case law can reinterpret the plain wording of the law, so there's potential changes here. HIPAA has 90 pages in the Code of Federal Regulations, but there's also this supplemental information that's posted on the HHS website. So 25 pages for the privacy rule, which is a summary, and 7 pages of a kind of a FAQ, if you will, as well, with security standards. And so the challenge is that software engineers often will just refer to this, and they don't look at the 90 pages, which is what we looked at. Okay? And so there's a lot of things that you will miss, and you may not be compliant with the law. And so these are things that we have to address. So as an example of intentional ambiguity, HIPAA says, protect against reasonably anticipated threats or hazards to the security or integrity of such information. So that's intentional ambiguity because we don't know what reasonable is yet. Right? But a language ambiguity is the covered entity must promptly document and implement the revised policy or procedure. Well, how promptly is prompted? So let's look at some past work with legal text that's been done. So Paul did a survey of all of the work, and there's a conference actually called, or a symposium that happens every 2 years, or workshop, it's AI and the law, which I was completely unaware. So he looked at everything that's ever been written in computer science having to do with the law. And I'll just touch on a few of these, but there's been logic-based approaches and software engineering approaches. And so I'll just touch on the bolded ones here. But these are all written up in a paper if you're interested. It's a really nice summary paper. So beyond technologic, the main idea is to capture the rights and obligations that are present in text. There are some pros. You can answer specific queries. You can maintain traceability. But the cons are that there have been very limited implementation efforts to date, and it requires manually encoding rights and obligations, which is actually a problem with several of these approaches. And it only captures a subset of legal requirements. Access control, the main idea is to derive privacy-focused access control rules directly from regulatory text. And so you can have kind of an auditable privacy system. So again, you can support queries, you can have traceability, you can have formal model checking. But the problem here is that it abstracts a lot of the critical details in the legal text, and you can omit low-level system requirements. And it's largely focused on rights and obligations as well. And then there's, in the software engineering community, we have reusable requirements catalog. This is work that was done looking at the Spanish Personal Data Protection Act, where you basically extract the legal requirements once, and then you reuse them in future projects. So you can identify unintended ambiguities. You can have the quality of the catalog improves each time you use it. But again, it requires manually extracting requirements from the law. There's no real evaluation of like how long does it take and how much expertise do you need to be able to do this and how much domain knowledge do you need. And every time the law changes, you have to manually change it. So there's no like perfect solution for this. So if we look at requirements for handling legal text, from requirement solicitation, we need to be able to identify the relevant laws and text. And this is a challenge because remember, all the information that we have available on HIPAA, for instance, when there's an amendment, they don't publish the new law in the Federal Register. So you have to be able to find each amendment, keep an eye on it, and then kind of keep your own repository copy where you have that. So that's challenging. And a lot of software engineers have no idea that this is the case, and they don't know where to go to find these things. We need to be able to classify legal text with metadata, and we need to be able to handle evolving law, which is, we've been talking about how to handle evolving requirements in software engineering, so there's a lot in common here with what we've been doing in the past. And then in terms of requirements analysis, we need to be able to prioritize legal text and exceptions and disambiguate the legal statements. And then in terms of traceability, we need to be able to trace references references across the laws and to the requirements. And we need data dictionaries to ensure consistency, and we need tool support for this. Yes?
Just out of curiosity, how do the lawyers solve this problem? And do they just know everything off the top, or do the laws have enough little clues that you can do some context jump?
So the lawyers aren't trying to solve the problem that we're trying to solve.
Well, I guess how do lawyers solve the problem of the fact that the information isn't all in the same place for the same problem?
I don't know the answer to that question, but they know that the information is not, and they know how to navigate the Federal Register, which is something that a typical software engineer doesn't know. Now, I will say that one thing's interesting. I'm going to talk about a study we did with the HIPAA privacy rule, a study that we did. And Travis is my PhD student who did that work. Travis was presenting this to the Carolina Privacy Officials Network. And we brought in Peter Swire, who Latanya knows. Peter Swire was co-author of the HIPAA privacy rule. So we brought in Peter as one of our keynote speakers that day. And he was sitting next to me when Travis was presenting the work. And Peter kept saying, oh my gosh, I feel so guilty. And so finally I said, why do you feel guilty? And he said, because when we wrote that regulation, we never thought about the fact that someone actually had implemented it in software. And we could have written it so differently. So that was a profound statement from him. And we've been advocating for people who are writing these regulations, everything from Real ID to HIPAA, you need to have technologists in the room. You need to have the people who are going to develop systems in the room so that you understand how you write this actually can affect.
Now that Cass Sunstein is involved in, he's the boss of the Federal Register now, so you made an appointment with him to...
No, I haven't, but maybe I should. Maybe I should. There had another question in the back.
Yeah, so there's this problem that you're referring to, which is this issue that the law is written in English and the requirements you want to be specified in a more precise way. So would it be a completely crazy idea to have the law specify the requirements in a formal way, say through deontologic logic or some other mechanism?
I think it would be a great annotation to the law. I mean, there's ways of writing a law. There are things that have to remain ambiguous. But if they understood...
Well, there's disjunction. There's disjunction in deontologic logic. I mean, if you want
Yeah, there is. There is. So that would be nice. I don't think we'll ever get there. But if we can have some small impact on people thinking about the fact that we have to develop systems to support it, that would take us a long way, I think.
Just one follow-up following Stuart's line of thinking. One of the things I always wanted to see from your work was the opposite, a tool for lawmakers to have, so that they can actually reason about what it is they're writing. Because too often, I'm sure there's too often these laws are done in the middle of the night, and negotiations are happening by email as they're actually drafting it, and the consequences downstream nobody ever predicted.
Yep.
You know, and so they just don't know. Yeah.
Yeah. Well, now that I have students who are doing JD PhDs, we might be able to do that.
And then they get reinterpreted by the regulation.
Yeah.
Right. Who might also.
So as an example of when things go wrong and things get a little complicated, we did an analysis of the JetBlue data breach a few years ago. This is work that I did with Chen-Feng He, one of my earlier PhD students. And so we heard about the JetBlue data breach. We're like, quick, let's analyze the privacy policy and see what we can see. And when we did our typical analysis, we're like, well, there's just nothing interesting here. They simply violated their privacy policy, period. But while we were doing that, and we did the analysis using our tool and everything, we realized, well, what's really interesting here are the data flows. And this is how we got interested in regulatory compliance. So JetBlue said, we don't use third-party cookies, and they did, okay, which was one thing. It said we will never share your information with anyone. So so let me go back a second. Department of Defense had a subcontractor called SRS Technologies. SRS Technologies had a subcontractor called Torch Concepts. Torch Concepts was working on software to be able to identify potential terrorists. Okay. So the TSA, on behalf of Torch Concepts, requested that JetBlue provide passenger name records to Axiom, which is the other big data broker, which we'd never heard about until we heard about the JetBlue data breach, by the way. So Axiom then gave Torch Concepts all of the information that it had about the 5 million passengers that JetBlue gave them. And then they put all of that information together to create profiles to see if they could identify potential terrorists. There were a ton of things that went wrong, like the company president actually giving a talk about this with actual data with people's social security numbers, which is like totally stupid. And a lot of other issues, including people being misidentified as potential terrorists because of anomalies or problems with the data, incorrect data. Okay. So, outrage. DHS and FTC both investigate. So it was right after 9/11, and JetBlue is in New York, so a lot of the other airlines were also asked for passenger name records, and they all said no. JetBlue is in New York City, and New York City was hit really hard on 9/11. And so they felt that they were, fulfilling, and helping their country by revealing this information. So when we started modeling all these information flows, we realized, well, isn't this interesting? Because this is when we started looking at things from the company's perspective. If I have a company and I have a good understanding of my data flows, and I can put an overlay over this that says, can't do that. You can't have this kind of information flow because that will violate either your policy or your law, or a law or regulation. Wouldn't that be extremely helpful for a company? And that's when we started looking at this from the other perspective rather than the end user perspective. So observations thus far. We need technologies for privacy enforcement and privacy auditing. We have a general lack of awareness about regulations and laws in industry, especially among software engineers. We have a lot of sensitive information that can be published, and I think it can be purchased from about people in the workplace with ChoicePoint and Data and Axiom, for example. And we need a way to explicitly state rights and obligations to ensure that we're operating according to our policies and our law. So, moving towards regulatory compliance. So, then here we have another article, Health Records Breaches on the Rise. The number of complaints regarding violations of HIPAA continue to increase each year in tandem with an increase in breaches of medical records according to one security problem. And a growing number of these complaints are still unresolved. We just don't want these kinds of headlines anymore. So what are our goals for compliance? So we look at two different objectives that we're trying to achieve. So one is due diligence. And due diligence refers to, I'm going to quote because this is from the law dictionary. Due diligence refers to reasonable efforts that persons make to satisfy legal requirements or discharge their legal obligations. And then we also have this notion of standard of care, which means that under the law of negligence or of obligations, the conduct demanded of a person in a situation. Typically, this involves a person paying attention to both possible dangers and mistakes and pitfalls and ways to minimize those risks. So what we want is for, if you have a data breach, let's say, if you can show due diligence in the way that you developed your software and your business practices, then lawyers have told me this would help them not have very heavy sanctions, and that if you provide due diligence, if you could prove due diligence, then you can kind of defend yourself in a court of law should something go wrong, because you've done everything within your power to make sure that you're trying to satisfy the law. So how do we get to that point? So we want to look at how we can extract rights and obligations. And so we have a methodology for extracting rights and obligations. This was Travis's dissertation work. And with each of those artifacts, we need constraints. We need to be able to identify ambiguities and resolve them. And we need to be able to ensure that we have traceability from the requirements all the way back to the regulation. So sounds easy, right? But it's really not. So here we have an example statement from the HIPAA privacy rule. And anything in red is an obligation. Anything that's underlined is a constraint. And then we have all these modal and condition keywords, which also complicate the landscape a little further. So we can then, here's an example, we can then extract all of our obligations and constraints from this. And I won't go into too much detail here. I want room for talking at the end. And we can develop semantic models. And so what's nice about this is that we take all of these statements and then you can query them. So you can start querying to figure out, well, can I do this or can I not within the space of complying with the law. And then finally, you can also formalize it. And so we can do this in Z, we can do it in description logic. It's a bit overkill, but it's important to show that we can automate this eventually. So that's why that's important. And so I mentioned the case study where we look at the HIPAA privacy rule. One of the first things you need to do is understand who all the stakeholders are as addressed in the law. And so here we have, very cutesy view of the stakeholders. Insurance companies, employers, financial institutions, et cetera. But if you actually look at the stakeholder hierarchy, it is insane. These are all the stakeholders in the HIPAA privacy rule. And what's really interesting here from a software engineering perspective, it looks so hierarchical, doesn't it? It looks like, oh, well, I'll just use, class hierarchy. Well, you can't, because there are a lot of things that some people can, so a healthcare provider is a covered entity. But there are things that a healthcare provider can do that a health cannot, and vice versa. So it's a really complicated landscape in terms of who can do what. An inmate is a person, but an inmate doesn't have all the rights that a person has. It's actually very interesting to study the law and read it because you learn all kinds of things about who can do what in this country and who can't. So when we analyzed the HIPAA privacy rule, we did 4 different passes through it. We did one where we were extracting access control rules. I always have a hard time remembering all 4 of these. One was access control rules. Another one was the priorities that are expressed in each statement. And so we developed these priority hierarchies to identify the exceptions. The other one was rights and obligations. And the 4th was software requirements. And what we learned is you can't just look at it and say, oh, well, all we really care about are the access control rules. Who can do what? because you also have to look at under what conditions you can and can't. And so you have to have all 4 of those passes through the law to really make sure that you're complying with it. And so that's what makes it challenging. One of the things that makes it challenging. So we can develop these requirements, priority hierarchies that help us to make sure that we are following certain things. So you can report, you can share information if you suspect that someone's been a victim of abuse, or if it's a gunshot wound, you can report it to the police, et cetera. So I'll go through this pretty quickly now. We identified 300 different information access requirements in the HIPAA privacy rule, and these are the kinds of things we found. There were constraints on these accesses that were based on legal determinations, medical determinations, personal beliefs, contractual statements, data subjects, and data purposes. And some of this is really subjective. And so I'll show you an example or two from each of these categories. So for legal determination, I'll just pick one of these. So number 3, for instance, you can make a determination about access by someone can do it who is authorized by law to report child abuse or neglect. So that's a legal determination that's made. Yes?
This coding, how much of it, these 4 passes, how much of it was manual? How much
It was all manual.
All manual.
It all had to be manual because it's never been done before.
How many
And so,
person hours was it to?
That's a really good question. And I know I have it somewhere, but I don't remember. And I should. Can you believe I talk about this all the time and no one's ever asked me that? But I can tell you that Travis came up to Purdue. This is when I was on sabbatical at Purdue. And Travis came up, I think it was 3 different times for about 3 days each. And we would sit in the Sirius conference room all day long, sometimes working until 10 at night. So I would say, a minimum of 9, 12-hour days, 2 people. And it's important that you do 2 people because I have never argued more with a student in my entire life. And the good thing about him is it was always about making sure, it was all about the integrity of what we were doing. And so, we were great friends after that, but it was always really trying to, because there's so many different ways to interpret it. And then when we had a question, we'd call someone like Peter Swire. When we really realized that we couldn't reach an agreement, we would call the expert. And we had another lawyer that we worked with at NC State too. And like, okay, here's the statement. We're interpreting it this way. Or, Travis is interpreting it this way. I'm interpreting it this way. What's the right way? And they would clarify. And sometimes Travis was right, and sometimes I was right, and sometimes we were both wrong. And so, you need to have all the players in the room. But it's intense. But since no one's ever done this before, we have to figure out how would you do it, because otherwise we can never get to a point where we can automate it. And remember, I work in requirements, so I'm all about what are the requirements to help people do this in the future. All right, medical determination. So who determines the use of disclosure is necessary to respond to an emergency circumstance. So then there are times when you can reveal information in that situation. Personal belief, talk about subjective. Who believes that the individual of the PHI is a victim of abuse, or neglect, or domestic violence. Contractual statements. Who has an agreement with an individual to restrict the disclosure of PHI. And then there are beliefs and determinations about data subjects. So there's information about individuals who are armed forces personnel or inmates versus someone who's suspected of a victim of crime. It's a lot to codify if you think about that in terms of software. And then finally, who engaged in procurement, banking, or transplantation of cadaveric organs, eyes, and tissues. So you see all over, just a huge landscape of things here. And then we have these normative phrases where we have anti-rights and obligations that state when a right or an obligation does not exist, and that also has to be codified in the requirements. And stakeholders can also delegate their rights and obligations to others. Okay, so for instance, when you sign over power of attorney, so you have to keep track of that in the system. Okay. So we have an example here of a right. An individual has a right to adequate notice from the covered entity of the uses and disclosure of PHI, and then the anti-right, the inmate does not have a right to receive notice of the CE, the uses and disclosure of PHI. So an inmate is also an individual, but should they also receive notice under the law? And so when we have these kinds of situations, we can handle these exceptions using De Morgan's law, applying them to the constraints, and also defeasible rules with defeaters. So there are different approaches to deal with these kinds of things. And then this is Calvin's perspective on rights. He says, I refuse to take out the garbage. I have the right to do whatever I want all the time. And his father says, no, I don't. He says, I don't? Well, I sure ought to have a right. And that's how you kind of feel when you read the law, fortunately. So in terms of detecting and resolving ambiguities, we look at triples. We have subjects, actions, and objects. Excuse me, well, 4 tuples, if you will. And we also have a target. So for instance, when you see that the law says something about providing notice to someone, if it doesn't say what the target is, then you know that's an ambiguity. And so what's nice about the being able to formalize this is that we can start to detect these things and deal with them before we start developing the software. We also have verbs that masquerade as nouns. And again, formal models help you be able to identify these so that software engineers can resolve them early on. We also have implied rights and obligations. And actually, Matt worked a little bit on a pilot study of this with us, where you can identify implied obligations. So the CE requires the individual to request an amendment in writing. So that means that the individual had to request the amendment in writing. And so these are all things that, from a software engineering perspective, you need that kind of completeness. So in summary, this was the first attempt to comprehensively analyze an entire regulation to specify system requirements, to make sure that we are accountably compliant with the law. That's a very important concept here. So if you don't employ systematic methodologies, you're really susceptible to security breaches, which is what we want to avoid. And also, if we do these kinds of things, we start reaching a point where we can prove due diligence, which is really important. And so finally, what time do you want me to stop at?
Go for a few more minutes.
Okay. Great. Okay, so then I'll talk about one more case study we did. So we did a case study with Cisco where we examined, I showed you this earlier, right? So I'm going to talk about this part of it. We worked with Cisco on a case study where they were interested in having us analyze the requirements that they have for software products that have to comply with Section 508 of the accessibility law. And so they heard Travis presenting in Minneapolis, and they said, we need you to apply your method to see whether we can come up with better techniques of making sure that we're complying with requirements. Manna from heaven for a PhD student to have that happen, by the way. So other than the fact that it took us like 8 months to get the NDA signed and the lawyers all happy and all that. So that always slows things down. So we had 3 research questions for this work. One was, how are product requirements written to exceed the law, the requirements of the law? And if they fall short, how do they fall short of compliance? What kind of gaps exist between the requirements that we were able to come up with and Cisco's? So we did the requirements using Travis's approach. And then what knowledge sources are needed to reduce legal ambiguity? So I'm assuming everyone's leaving because they have something to do at 1 rather because I'm boring. That's always the challenge with a talk that starts in a half hour and ends like that. But I'm glad they came. So the relevant law we were working with was the Rehabilitation Act Amendments of 86 and 98. And clearly this is important for a lot of individuals in the US because we have a lot of individuals who are impaired in some way. And we also looked at the accessibility standards, and that governs telephony, hardware, software, audio, video, and the web. So our units of analysis, we looked at what people were permitted to perform with the software, obligations, refrainments, and also exclusions. And the materials that we had were the requirements that we acquired and also the product requirements that Cisco had developed as well. So here's an excerpt from the standard. It said, when an image represents a program element, the information conveyed by the image must also be available in text. And so we have kind of a template for doing this where we look at the precondition on the object, modality, etc. So we're kind of developing little schemas, if you will. So in terms of answering question number 1, how are product requirements written? Well, it was very interesting how Cisco did this. They have a community of practice that basically coalesces everything that they can learn. And so they worked closely with IBM, who's published a lot of things on their website about accessibility standards, and there are working groups that they collaborate with. And so it's really nice because you see people spanning different companies who are usually in competition with one another to helping each other to make sure that people really understand the accessibility law and develop standards. And so that was great. They also keep track of things like blogs, the GSA, and US Access Form as well. So that's how they do that. In terms of requirements number 2, what kinds of gaps exist between legal and product requirements? We define the gap as existing if there was a paragraph in the standard that's not cross-referenced in either the Cisco or the NCSC requirements, and if there was a requirement in one set that didn't appear in the other. And so we have metrics for looking at this. And so we have goals. So requirement A describes why requirement B should be implemented. We have refinements. We hit equivalent to requirements were equivalent across the set. And maybe they weren't comparable at all. And that was another metric that we were looking for. We also had requirements metrics. So we had generalizations, we had missing constraints, refined concepts, new constraints, and modality changes. And so modality change would help you identify conflict in some way. So we did a gap analysis, and here the C stands for Cisco, the N is for NCSU, and the B is for both. And the pink shaded cells represent a band of non-functional requirements in the access standards that can cut across other functional requirements. And so we found, unfortunately, this is where I get really frustrated because we had really interesting results and we can't talk about them, which is when NDAs kind of conflict with what we want to be able to do in academia. But we were able to find some gaps that helped Cisco, and we were also able to find overcompliance, which is good as well. And so you can kind of refocus your area. So it was a very interesting result. Cisco was very happy with it. They were able to identify requirements they needed to comply with the law. So we identified refinement patterns. So this is a way in which you can make sure that the legal requirement yields a new legal requirement or a policy requirement. And so we have simplification patterns and clarification patterns. And so there's a paper on this from, we presented it REO 8 if you're interested as well. So just in general, the contributions here is that we were able to identify compliance gaps between the Cisco product requirements and the accessibility standards. And we were able to develop we need to develop new metrics for comparing requirements and refining, and more refinement patterns, because we've been able to do this in one domain. But if you try to apply this to another one, you won't have the exact same results. And so we're always trying to find ways that we can generalize our work. And what was nice about this is that we were able to apply work that we've done with HIPAA, which is one specific domain, in a new domain. And we were able to reuse some of the more generalizable heuristics and approaches in Travis's work. So, in summary, a lot of what we do in terms of looking at privacy policies and law has a lot to do and very common and similar with what we do in software engineering. There are tools and techniques that we use in requirements engineering that are useful for identifying policy and law. And the challenges cannot be addressed with technology alone. You have to work with domain experts. You have to work with lawyers if you're looking at the law. You have to work with sociologists if you're looking at for instance, the user value surveys that we do, et cetera. So it's really important to not look at a problem just from your own, if you're a computer scientist, your own perspective. You have to work with people outside of your area. And so we have a systematic methodology for extracting stakeholder rights and obligations. We can manage traceability. We can look at multiple viewpoints given the perspective of the rights and obligations. We have techniques for prioritizing rights and obligations, and we can detect and resolve some ambiguities. And then some limitations, we've only done this for privacy and the ADA standard. We need to do more. We have plans to apply this to the environmental regulations and aviation standard. This is work that John Knight at UVA has been encouraging us to do with him. And current and future work, we need to evaluate the method in other domains and look at other software artifacts as well. And some of the work we're doing now, we have iTrust, which is a software system that's an electronic health record that Dr. Lori Williams is developing in NC State. And so we are developing tests for HIPAA compliance with that. We have a paper that was just accepted to RE for this year on some preliminary work here, looking at how we can establish traceability. And so it's really interesting. This is a requirements document where they say, this software is HIPAA compliant. and you look at the requirements document, and there's nothing in there that makes it HIPAA compliant. And this is basically the state of the world. It's like there's all these systems. So what we're trying to do is help software engineers figure out how do you go back and look at your requirements to make sure that they are compliant with the law. And then just some general recommendations. If you're developing privacy policies, make sure that they're understandable, that you have focus groups, and that people, you know that they understand it, and that your policies are compliant with law. Legalese is ambiguous and difficult to support, but if you have some formalized methods and tools, you can get closer to achieving that. And analysis exposes ambiguities. It helps you make decisions to try to prevent abuses and privacy breaches. And I always have to give hats off to all my collaborators, a great group of students. These are students who have contributed in some way to the work that I've presented today, and those in red are ones that actually were leads on some of these projects. And also, I have to thank National Science Foundation and CRA, all our supporters. And I'm happy to take any questions.
One area that would be very valuable for the educational world is FERPA. Using your analysis of FERPA. Revised regulations, and there's nothing
So I haven't looked at the revised regulation, actually.
came out in February.
Okay. So that's interesting.
In effect now.
Well, boy, they gave everybody a lot of time to.
Well, it came out, the first reading came out
Okay. So that's interesting. I imagine part of that is in response to things like Virginia Tech.
specifically in response to that.
Okay.
But that's one area of health and safety, but there's a lot of other things restricting access to people that have business needs and other kinds of things.
Right. I have an amusing FERPA anecdote, which is that I once had to turn a student in for plagiarism. And I got an email from his father. This is a graduate student, mind you, right? So, you know, if you're in grad school, you have to have your parents contact the university. It's a statement in and of itself. So this father sends me an email, and his signature says that he's a full professor at another Research One university in another field, not computer science. And he wanted to know the details about this, and he wanted the information, he wanted a copy of the paper, and he wanted all his son's grades. And I said, well, I just was floored from another professor, right? And so I said, well, as a full professor, I'm sure that you are well familiar with FERPA, and that I'm unable to provide this information with you. If you'd like, please feel free to contact the university, which he did, and he sued the university. And the case was quickly dropped because there was a leg to stand on, right? But yeah, so that's my FERPA anecdote. Someone else around here had their hand up, I think. Yes?
Can you talk a little bit about metrics? I'm not very familiar with the sort of software engineering compliance field, but when you say that something is 231% more compliant, how should I interpret that?
That's a really good question. And I would say, but I would have to check with Travis to make sure I'm answering this correctly. So if you send me an email, I'll get a real answer to you. But if I recall correctly, it meant that they had more requirements than they needed to have to satisfactorily comply with a certain requirement and standard.
So to take a step back, in computer security, you say, listen, security is a process, and then someone's pushed back against that recently, saying, no, security is actually about results. Would you rather, if you're a CISO, would you rather say, listen, we did these 18 best practices, we spent this much money, or would you rather say, we didn't have a breach? When you talk to people about compliance, how do they look at compliance metrics compared to outcomes?
So this is a completely new field, so I don't have an answer to that specifically. Okay. I will say, however, that there were things in the standard that you didn't have to comply with, but that they kind of say would be nice.
Okay.
And I'm pretty sure that we were counting that in that figure, those kinds of things. Okay. But I don't know how to answer your other question because we haven't talked with folks about that yet. Hema.
So I know you talked about the case studies on privacy policies. I think I did some work with you for one semester. We looked at the companies that are actually, we looked at like medical companies, right? They are actually provide a service and in return get money. So they have to, their obligations on privacy is somewhat different from, let's say, an open source software or a service that's provided. Let's take an example of Facebook or Delicious or any of those, Twitter. The standards are much different there. And how do we make them comply? What are some of the, is the research community even focusing on that? And the privacy, PII, is much different in those spaces than when you look at a traditional on-premise software, right?
So, so this is a really interesting space. And one of the things I was most concerned with when Microsoft came out with Health Vault is that if you read their policy, it was actually very Facebookish. And the way that applications were adopted in your personal health record was very similar to that you're giving access to all that to the developers and all of this. And so that was a real big concern to me. And the challenge is that people care a lot more about their health records and about their financial information than they do about whatever you choose to put on your Facebook page. Okay? So as computer scientists, we know that what we put on our Facebook page, informed computer scientists, we know, it could appear on the cover of the New York Times in a heartbeat, right? But you don't expect your health records to. And so when people don't understand how to control that, and they entrust their information to these kind of Facebook-like health record systems, it's really, really scary. And there hasn't been a lot of work in this space. Last night at dinner, we were talking about, I mentioned to Latanya that in California, they now have a law where if you have a PHR system, which before this law, it wasn't covered by HIPAA. And so if you looked at how Microsoft and Google Health were getting around this, it was because they weren't accepting any monetary transaction from you. So the minute that they would have sold this service to you, they become a covered entity. Okay, so that's how they were skirting the law. But now there's a law that in California, PHRs are covered entities. And
Also federal regulations taken in that direction.
right, absolutely. And so, and of course, as with everything in the United States, the law is always trying to catch up to the technology. But Latanya had a really interesting approach that she was talking about last night, where it's you don't want it to be covered by HIPAA. You should focus on contracts. And so I thought that was a really, really nice approach, because HIPAA's not that great, in all honesty. So,
And then the contract will allow me to sue them.
right.
But so if you build, like, so Microsoft Health Vault, I think it's so much like Facebook that they're actually like very easy for people to come along and say, hey, would you like to share your information with us in exchange for something completely trivial? Under a contracts framework, how do you, and since it's all voluntary as opposed to top-down regulation, listen, the entity has to do due diligence to make sure that the personal information is sharing versus if a contracts arrangement, it seems that I as the individual choose to share my information with Pharmaco.
I want there to be an offer of consideration and acceptance. I want all the terms of the contract to be met. And therefore, it doesn't have to be money. It might be money, but it doesn't necessarily have to be money. It might be exchange for goods or services. But I want it to be very clear that all of the terms, there are many people that are giving me promises in the equivalent of a privacy policy. They're not just promises. I have a right to sue you if you
Right.
A couple of different things. One on the right to sue. Today in the U.S., the primary thing about privacy policy on the web page is that it has to be accurate. It doesn't actually have to fit any digital set of criteria other than the California law components of that. But it just has to be accurate, otherwise the Federal Trade Commission
Right.
It doesn't actually say anything. It's very different in Europe. Have you looked at the European privacy rules?
So this is a really, so I haven't closely looked at them, but I can say that I have some work that we did, we haven't published for a variety of reasons, where we actually looked at the privacy policies of all the American airlines. I was talking about this at dinner last night. And we called them in alphabetical order, and we also sent emails. So anything that they saw in their privacy policy about how you can contact them, we either called and or sent email. And so the email said, we have read your privacy policy, and we have a couple questions about it. So we had 3 questions that we asked of all the policies, of all the companies, and then 3 more that were specific to that, to each company. So and about a week later, you get an email. Thank you for your email. We suggest that you first read our privacy policy before you contact us. Right? And our first sentence was, we did. And then we also called them. And we called Alaska Airlines first. And so within 10 minutes, we got a call back from the guy who wrote the Alaska Airlines privacy policy. We were really impressed. And I thought, finally, maybe we found the right industry who's doing it right. Forgetting that this was just happened to be the first airline we were calling. And Alaska has done something where they had someone write the policy for them. And he works maybe like 1 day a week at Alaska. And he's on call 24 hours for them. And he actually called us. It was the only person I've ever called that we've spoken to, right? So we thought it was a really interesting model. We thought, well, maybe that's the right way to go. Maybe you don't have to have a full-time chief privacy officer. Maybe you just need to have someone who has talked with, well, that's the thing. He'd also talked with the CISO and to make sure that it accurately reflected what they were doing. He's a very, very knowledgeable man. So we're very impressed. And then it went straight downhill from there. So when I talk about this, I usually talk about the good, the bad, and the ugly. So I gave this talk in front of a bunch of lawyers at Georgetown Law School. And I said the good was Alaska, the bad was, I don't remember who, and the ugly was United. Can't forget that, because they yelled at us on the phone after like an hour and 40 minutes of talking with them. So, from India. Yeah, we were yelled at by someone in India. Like, yelled at. We were like, I can't believe this, how unprofessional. So they became the ugly very quickly. So I give this talk, and a guy comes up to me afterwards and he says, I just had to introduce myself to you. I'm the good. He was the CISO for Alaska Airlines. And all throughout the afternoon, everybody was like, well, we don't want to appear in one of Dr. Anton's studies, so let's make sure we're doing this right. And we also did an analysis of international airlines. And the challenges that we ran into is that, for instance, what they said so I'm fluent in Spanish. What they say in the English version of their privacy policy and what they say in the Spanish version is different. So then we got to the point where, so do we do an analysis of both, right? And so in the Spanish ones, they talk a lot about the European law and how they're complying with European law. In the English version, they don't say anything about it.
That's because of different assumptive audiences?
I imagine. I didn't have time to really explore that further. But we are very interested, and I can tell you that when we've presented this to several audiences, they want that information. They want to compare it with European and international. And so it's work that's on the back burner that we want to get to.
And the in-between state is to look at the U.S. safe harbor rules.
Right. If you want to send more students my way, that would be great. Because this takes a lot of manpower, actually. So.
Since you have such a wonderful instrument for privacy policy comprehension, it'd be very interesting to see how your American audience understands European privacy policies.
That's true.
And whether we've been trained to think
differently
explicitly in the Grand Leaf, Blind Leaf framework.
Have you analyzed the NC state privacy statement?
Oh, don't get me started there. So I didn't do it today because the nature of the talk was different. But when I go to universities to talk about stuff that's just general security and privacy, I always do a little analysis. So when I went to Dartmouth, I did an analysis of theirs.
I would appreciate something.
Oh, okay. Yes, when I did Dartmouth, they said we don't collect information, we don't collect any financial information. So when they said that, I was like, bingo. So I did a search on donation in Dartmouth, and I found the site where they actually collect credit cards.
We say that the statement has to be relevant for the group, for the area. But I did force them to add the fact that he was getting blue lens, which they didn't.
Oh, interesting. So the NC State privacy policy is basically a legal disclaimer. This is absolutely nothing about privacy. So I was asked, they have a fabulous faculty lecture series at NC State. So I finally did the NC State analysis. And so that privacy policy says, and you can contact the chief privacy officer. So wow, we have a chief privacy officer. First time I've heard of it. And I looked, and it was the legal office, right? And then I did a search on NCSU and Chief Privacy Officer. And then I found another site that had different Chief Privacy Officer, and that sent you to Information Technology. And so, and then into HIPAA compliance, right, with the health, and everybody had a different person that you contact. And so we now have a new CIO, and he's come to talk with me about it. So I'm hoping that we can finally get a good privacy policy in NC State. And there's talk about hiring a Chief Privacy Officer for the Institute as well. So we're moving there, but it's been slow.
We do not have a chief privacy officer, chief security officer.
Well, wouldn't you love some help?
I was talking to the OGC 3 days ago, or last Friday. They're pushing to take a lead, politics involved.
Right. Are you? I'm sure you're familiar with EDUCAUSE, right? So it'll be interesting to see. I think EDUCAUSE can do a lot to drive that.
What is it?
EDUCAUSE drives in multi-directions at the same time.
EDUCAUSE is basically you can correct me if I'm wrong, it's like a consortium of all the IT officers at universities. And so it serves higher education IT. So,
Some of the people that sue the U.S. government over CALIA.
right.
Thereby raising the profile of the CALIA thing way beyond what it should.
So you had asked about public policy, or you had asked about public policy. You should follow EDUCAUSE if you're interested in that space, Tom.
They give advice to
And the president just happens to be the wife of my chancellor in NC State. Although I should note, she's extremely accomplished in her own right. So she's really amazing. So, any other comments or questions? Okay, thank you very much.
Thank you.